Thank you all for joining us. I'm Jeff Hochstetler. I'm the director of the Ethics Board. I'm the Inspector General's designee.
When you sign up to be a public servant through city employment, you're signing up to actually serve the public, not yourself, not your family members, not businesses or other organizations you might be affiliated with. And that's where the ethics law comes in.
The ethics law itself, which is what we'll talk about today, contains a number of rules to make sure that that happens. In fact, the rules try to make sure that there isn't even an appearance that you're putting someone else's interests above the city's. Ethics overlaps with morality. It encompasses some right and wrong, but in a lot of ways, it's also about a mindset. I'll be the first person to acknowledge that the rules can be a little complex and confusing in places, but that's where the mindset itself comes in. You all are very busy, may not always have time to look back at this training or look into the ethics law to see what the specific requirements for a situation might be. But having that mindset is important because it's sort of being attuned to when something doesn't seem quite right, or when an outcome or an end might be seen as justifying the means, or might appear like someone else's interests are being put above the city's. I'm here to help you think through all of those situations. That's my job, and it's the way that I'm currently serving the city, and I'm honored to serve the city that way. The ethics law primarily is about promoting the fairness, impartiality, and independence of public servants. And to that end, it has three main goals. These are actually spelled out in the law. It sets the minimum standards of ethics conduct. It requires disclosure of your financial interests, and it requires public registration and reporting for lobbyists. So in that way, ethics is also really about transparency, and not just transparency to say, well, you have to put this out there so the public can see it. But I think the idea is when you're working through thinking about the financial disclosures you might need to make, it should be an occasion to think through the conflict of interest that you might potentially face. Since you're supposed to be solely serving the interests of the public as an employee, a conflict of interest arises when there might be some other interest you're serving besides the city's. And this is really where you ask yourself, how do I stay out of trouble or off the front page? It usually comes in the conflict of interest scenario. There are a lot of different categories and scenarios that could raise conflicts of interest, and the ethics law tries to spell out and capture most of those actually. But there are three main categories. One is where recusal is required in your city role. One is where outside employment or other interests, you need to actually stay away from those because the conflict looks so great. And then the other one comes in the gift scenario. Everyone's favorite topic. So we'll cover those three broad areas of conflicts of interest. So let's start with conflicts of interest that would require you to recuse yourself from a matter or refrain from participating in it. It's not just council members or other high-up public officials who have to recuse themselves if there's a conflict of interest. Recusal simply means not participating in any way. And the matter at issue doesn't just mean legislation or some other important policy decision. It can mean reviewing applications or contracts, taking part in procurement activities, really anything. You asked two main questions about recusal. Is the matter itself that you're working on and your participation in it eligible? Well, this is really broad. It could be any contract or claim or proceeding, an application, a submission, a recommendation you're making, or if you're reviewing any of these types of things. Any of those matters could be matters that are eligible for recusal if there's a conflict. And then the second question is your role in working on that matter sort of significant enough to think about if recusal might be required? As long as it's not simply administrative or secretarial and it involves some degree of discretion, it could be a matter you need to think about recusing yourself from if there's a conflict of interest. So what kinds of things might create a conflict that you need to think about recusing from something you're working on? One is kind of broad. You or a disqualifying relative have an interest in the matter that you're working on. The ethics law has a very specific realm of relatives, and it's just spouse, parent, child, or sibling when you're thinking through potential conflicts of interest. Interest for purpose of the ethics code does not include things like insurance policies, publicly traded mutual funds, pension and retirement plans, tuition plans, and things like that. I think the idea there is we all have financial interests just in order to live our lives in things like insurance and potentially in our retirement plans or mutual funds. And it would be a really big task to try to figure out if matters that you're working on might implicate those types of interests that you have. So the law just takes those out.
All right, second category of recusal is when you or one of those disqualifying relatives are employed by a business entity that is impacted or is a party to the matter. So an example here would be where your spouse or child might work for a neighborhood organization that will directly benefit from a city program or grant that you're working on. You would need to recuse yourself from working on that particular program or grant, for instance. This idea of when someone is a party to a matter can be a little unclear. The State Ethics Commission, whose lead we often follow, simply says that someone's a party to the matter if they could be impacted by it in some in some direct way apart from the general in a different way than the general public is. So any legislation or any matter might impact a lot of people, but to be a party to the matter for purposes of thinking about recusal, it'd have to be somebody who that's directly directly impacting. So somebody who's signing a contract, or somebody who's specifically going to be getting a benefit under a grant or something like that. The ethics code does define a business entity very broadly. So it's any person, and then person itself is very broad. So it could be an individual, anybody involved in organized activity of any kind. It could be for-profit or not-for-profit. It could be what you generally think of as a large corporation, or it could be a solo practitioner or a sole proprietorship. Any of that could count as a business entity. Houses of worship as nonprofits, they're probably organized. They're engaged in organized activity. They would count. And in Baltimore especially, I know there's some large churches, and they often play a role in community outreach and development. So yeah, it's good to keep in mind that your relationship with the church could count if you're on that church's governing body. The third category when you need to think about recusal is when you or a relative, as a partner, an officer, or board member, are affiliated with one of those business entities. For instance, let's say you or your sibling serves on the board of a community association, or let's say a church that will directly benefit from a revitalization program or something like that. You would need to consider recusing yourself from working on that particular policy or proposal if it's going to directly impact that organization that you or the relative has a relationship with. Fourth category is if you or your relative has a financial interest in a party to the matter. And the code has a pretty strict definition of what counts as a financial interest. The code specifically defines financial interest as ownership of 3% or more of that business entity, having received $1,000 or more in any one of the past 3 years, or if you're entitled to receive more than $1,000 in current or subsequent years. So maybe, if it would be a dividend payment or something based on stocks, and you knew you could get $1,000 in that in the current or subsequent years, that might all count as a financial interest in a business entity. An example of having a financial interest might be, let's say there's a major revitalization grant, and your sister is part owner of a development company that owns property in the neighborhood slated for development. You might need to consider recusing yourself in that particular scenario. Another one that I think comes to mind sometimes is, let's say your sibling is part owner of a construction equipment supply company, is hoping to win a procurement contract from DOT for snowplows. You would need to recuse yourself if you were playing any significant role in awarding that contract. Fifth category is when you or a relative has a financial interest in an entity that itself has a financial interest in a party to the matter. So it's sort of one degree removed. So here, for instance, maybe your spouse's company owns real estate, owns a real estate LLC that might get a benefit from that neighborhood revitalization grant. Well, here, even though even though it's the subsidiary company that's a party to the matter, clearly the parent company has some clear benefit. You might need to think through recusing yourself there. Number 6 is similar. It just sort of reverses it. So if you or your relative's financial interest is in a company that is owned by a parent company that's party to the matter, that's going to benefit. So here, let's say your brother's construction company is owned by the developer that stands to benefit from the neighborhood revitalization grant or something like that. You could think through that affiliation and think about recusing yourself. I mean, as you can see, the ethics law tries to account for all these various degrees of relationship, and I know it can get complicated. So when in doubt, ask. Seventh category is if you or one of those disqualifying relatives has a contract with a party to the matter, but if that contract could result in a conflict. So here you'd really have to take a look at the subject of the contract and see if it might cause a conflict with the particular role that you're playing in the matter. Let's say your child has a services contract to supply carpet to a hotel chain or something, and you're involved in approving a franchise agreement with that hotel, working on that franchise agreement. That might trigger this category of conflict of interest. The bottom line really is, if you're trying to figure out whether you need to recuse yourself from participating in a matter, you just need to be aware of these multiple ways that you could be affiliated with an entity that is impacted by that matter. So it may be worth putting together a list of you or your relatives' business and financial interests, and routinely reviewing it during your work and your duties, and thinking through when there could be an issue that arises.
Another one is if you have a debt or substantial obligation to a party to the matter, you shouldn't be in a position to give someone a benefit through your city role if if they have if they're holding a debt over you. That might look a little bit like a quid pro quo or something like that. So again, it's both about appearances there and potentially actual conflict. And then the last category in recusal scenarios is if you just came into the city and you happen to be a lobbyist for that same matter within the past calendar year, you also can't work on that matter.
So there are some conflict of interest recusal exceptions where even though there's a conflict of interest, you still wouldn't need to recuse. As we already talked about, if your involvement is only what the law calls ministerial, you don't have to recuse. So that would be purely administrative, sort of purely secretarial. There's no decision making involved, no discretion involved. Next one is if the Board of Ethics specifically says you're allowed to participate, notwithstanding a conflict. I'm not aware that there's any broad rule or regulation that the board has put out yet to say that in all scenarios, in all specific scenarios of a specific kind, you would need to recuse yourself. But it could put out an individual opinion just applying to you if you think that you don't need to recuse or you shouldn't recuse even though you might have the conflict. If you happen to sit on a city board as a representative of a particular industry, you wouldn't need to recuse yourself when a matter comes up that involves that industry. Now, this one does come up with the city sometimes, and especially elected officials. If those officials, or as their designee, happen to be on a board on the city's behalf, and it meets these requirements, you also wouldn't need to recuse if there's some conflict when it comes to your city role and sitting on that board. So the 4 criteria to meet there is, let's say the mayor sits on a particular development, neighborhood development board as the mayor or a council person. Because the city had an economic or programmatic interest in that board, and he was serving in his official city duties, and he's not receiving any compensation, he could sit on that board and then not have to recuse if something that board does might conflict with his other city role. He'd still have to think through whether he needs to recuse if he has one of these other personal or relative conflicts of interest that we talked about. If a board or commission would need a specific person to take action on a matter, or else they wouldn't even have a quorum, maybe in that case they could still act even if there's a conflict of interest, or if they're required by law to act, even if there's a conflict of interest, they could still participate. In that situation, though, they would still have to disclose the conflict of interest to the board or their agency, and they would also have to let the ethics board know about it as soon as possible afterwards.
If required by law to act, or if you're the only one who can act, the only caveat there is you still have to disclose the nature of the conflict of interest before you act, and at least to your agency, and then you can disclose it to the ethics board as soon as possible after acting.